Good morning. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the Chicago Department of Business Affairs and Consumer Protection webinar. Please note any website or email that I mention will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall on the 8th floor or call 312-74-GO-BIZ. Also, business licenses can be applied for or renewed online at chicago.gov/business licensing. The BACP Entrepreneur Certificate Program now has a new portal. If you are already a part of the program, your account will automatically reflect the credit for joining this webinar within 24 hours. If you want to learn more about the program, please visit chicago.gov/BACP certificate. Also, this webinar is recorded and will be available at youtube.com/ChicagoBACP. I will post the mentioned information in the chat box. We encourage attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session during the presentation and at the end. Please note that the views, information, and opinions expressed during this webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar will be Setting Yourself Up for Faster Payments and Better Collections of Your Accounts Receivable, presented by Jensen Smolka, shareholder at Robbins DiMonte. Julia?
Good morning, everyone. And thank you, City of Chicago, for having me. Again, my name is Julia Smolka. I've been a business and collections attorney for 23 years, and I live in Chicago. I live in Edison Park, if you know that area, up on the northwest side. And I've been practicing in this area for a long time. And today, what I want to do is talk about how you as a business owner, you as an individual running a business, overall, what options, what things you can do now when you're getting into business with someone to set yourself up for better collections. And then if you do need to go to an attorney to help with your collections, what kind of options you have, what kind of things an attorney can do for you, and what we would need. Because there's stuff you can do at the beginning that would be very helpful for us as attorneys if we go ahead with, having to sue or do those things. I'm at a firm called Robbins DiMonte. We have offices, we have in downtown Chicago, and we also have them out in Park Ridge, right by O'Hare Airport. So I encourage, as we go along, I know there's a lot of you on today, but I do encourage you to, if you have a specific question about something to your business, I'm not really going to get into your contract or your business direct, but if you have overall questions about what I'm talking about, or you have a question as I go, feel free to put something in the chat. And our moderator is going to be watching the chat. And then as I pause, she's going to be interrupting me with those questions. And I hope that makes it lively and interesting. Figure we're going to go about 40 minutes or so. And then if you have questions at the end, I'll stick around, for 5 or 10 minutes to answer those questions. So let's go ahead and get started. And I'm running so if you see me look this way, it's because I'm changing the slide. Okay. So again, we're going to talk today about basic contracts, what's involved, what they consist of, basic asset protection, because you as business owners, I want to talk a little bit about how you can set yourself up to protect your personal assets. Again, we're going to spend a few minutes on this, just so you have a better idea of why people incorporate, why people form LLCs, and the protections that they give. Collections of receivables. Again, so this is the legal aspect of, what we can do and what you can do to collect those receivables. And we're also going to talk about bad checks a little bit, because those still, even though we're moving more and more paperless, and more, Zelling money and wiring money. And there are still bad checks out there, and we're still, and there's a lot of statutes and things that are involved with bad checks that I want to talk about. Okay. Okay, so let's talk about what a contract is. And a contract is just simply an agreement between, two people or two companies, or, a homeowner and you as a plumber. Each agrees to do something. And again, the contract, so, you're going to agree to perform a service, perform materials, and they're going to agree to pay you. That's kind of like the basic. So again, we need performance, some kind of agreement on performance, and we need, the action to take place. And then we need, that should trigger the other person to do something. So let's talk about the basics of a contract. Now, contracts, they can be oral or they can be in writing. And sometimes we see this in exchange of emails. So a lot of times clients will come to me and they'll say, oh, I hired, ABC company to put up gutters, and we talked about it. They started putting up the gutters, and then they went away. And I'll say, okay, well, do you have anything in writing? And if they have nothing in writing, they think they have no recourse. But again, it could be simply an oral contract. Obviously, it's best that contracts be reduced to writing, because again, when you have something reduced to writing, a judge or a third party, an attorney can see what the promise was, whether, and what, whether there was a timing involved, whether there was something specific to, so in the gutter situation, was it going to be copper gutters? Was it supposed to be aluminum gutters? Were they going to be vinyl gutters? What color were they supposed to be? When were they going to get installed? We're going to get installed this year or next year. Obviously, written is better, but still, oral is still actionable. You still have a cause of action if there's an oral contract. All right. So if you're going to have a contract, some of the basics you have to think about is you have to have the party's name. So you'd be surprised how often people come to me and they say, oh, I have an agreement with so-and-so. And in reality, the so-and-so is a company. Like, what's the actual company's name? Did you contract with an individual, or did you contract with their company? Because that determines who we sue and who we send demands to. Because a lot of times people, especially homeowners, oh yeah, I hired Joe to do this, and really Joe is ABC plumbing contractors or ABC, whatever they are. You need terms in your contract. Again, who does what for whom and for how much. So think about when you're doing your contract, like if you're designing a website, what are you supposed to be designing? And are you supposed to be prepaying for the domain name? Are you supposed to be prepaying for the space on, the, what do they call, like WordPress or Wix or whatever the platform is? And when are the payments due? You as a web designer, you don't want to undergo all this work. It could be, 15 hours of work and the payment done at the end. You might want to structure your payments in a way that triggers them earlier. So I'll give you an example. I just had a small addition put on my house. And the contractor gave me this contract, and he just said, okay, the total price will be $62,000. I want half now and half when it's done. And I'm thinking to myself, and again, I've been doing this 23 years. I'm like, why on earth would I sign this contract? And I know he has to buy materials. Again, he has to order the windows. The windows take 5 weeks. You order them and they're custom done. So I know there's a reason why he wants money down, but I'm not going to agree to that. So he and I talked, and how we designed it was, okay, it's $62,000. He will get, because the other thing is he had me reserved in the summer. right? So we signed the contract in February, but again, the work was going to start in May, May 1st. So he wanted to make sure that I was in for it, wouldn't change my mind, the day before, right? So what we did was it was, 5,000 at the time we signed the contract. And then again, to trigger the prepayment of those windows and those things that I had to pay, we had then like 10,000, on, by March 15th, so we can order those materials. And then we had, okay, when he got to the work site and dug the foundation, it was another payment. So we talk about what triggers the action or payment. You want it clear because you want to be able to, as a contractor, you want to be able to say, whoa, hey, I was supposed to get paid by now. It should have been 50%, by the time I got the walls up. And you don't want to get ahead of yourself. So as a contractor, you can point to the contract to the homeowner and say, listen, I was supposed to get payment number 3 when the roof went up. The roof's up, look up, the roof is up. I want that payment. And that also is important for you as a homeowner, for you to say, okay, because a homeowner can't tell, if you say rough in plumbing or rough in, when you're 50% done, we want 50% of the money. An individual's not going to be able to tell when that is. And likely a judge, if we had to go to court on this, a judge wouldn't know, hey, when is that? But if you put natural trigger actions into when payments are due, if it's multiple payments, you will be able to better be able to point to a court, hey, the payment is due, or to your customer, hey, this payment is due. And then you're able to stop work if you need to, or stop the delivery if you need to, which would kind of force the issue. And when you force the issue, that's when you can likely get paid. So in the example of me putting the addition on my house, one of those, I did six payment times. And one of those payment times was, again, when the roof was enclosed and the siding was up. Because again, the house I had, it was, it was like an hour away from where I live. And the contractor was able to show me pictures. Look, the roof is on, the siding is in. And I could agree, fine, I'll send you the next payment. So think of, in your business, if you have a longer contract or a longer receivable, how can you draw that up, the agreement up, so that both your customer is comfortable and you're comfortable, because you're not outlaying money. Because a lot of times clients come to me and if they're a contractor, they already put out a bunch of materials or a bunch in labor, and they're upside down on the contract. Or as a homeowner, they've already paid 75% of the contract, but they have just the shell up, and not 75% of the work is done. So those triggers and those payments, the clearer you make it and the more fair you make it for yourself and for them, the more likely it's going to get paid. Okay. And we talked about terms a little bit, but the terms should be, you want to make it clear. You want to make it so it's not convoluted, what you're going to do, what you're going to supply. If you're building something, if you're providing a service, what's entailed in it. Okay. So that, again, if you had to explain it to a judge who has no idea who you are and what the contract is about, the judge could simply read it, and he or she could say, okay, you were supposed to, build a new deck. It didn't just say work, do work on your house for 15,000. Again, you explain what it is you're supposed to do. And while it doesn't have to be super specific, it should be clear enough so that a lay person can know what you were supposed to do and when you were supposed to be paid. Okay. And every industry is different on how their contract should be. Okay. All right. So a contract, another thing you should think about doing is putting in an interest provision. And the reason you do this is that you want to give incentive for people to pay you because they don't want to pay interest. So if you think about it, Think about your own budgeting and your own, for your own business or for your own household. If you have 10 bills that have to be paid, and your mortgage, if you pay late, it's going to be a $50 late fee plus interest plus whatever else. You're more likely to pay that than maybe a doctor bill. If you only had $1,000 and your doctor bill had no interest charge or no late fee, you're going to say, well, I want to prevent the interest charge. You're going to pay the one with the harshest interest or late fees. So in your own billing and in your own invoices, you should think about putting in a provision for interest or late charges. So I just have on the screen, balances over 30 days are subject to interest at 18%. And again, 18% is a bit, it's a big one. So people might look at that, and you might choose to issue it, or you might choose not to, but it's a tool where, again, you want to give the incentive for your customers to pay you and pay you quickly. And one of the things that I've done and our customers do when they have these interest provisions, and when you're going back and forth with a customer trying to collect the outstanding balance, you'll say, listen, you owe $5,000, but $500 of it's interest. If you pay me $4,500, if you send the money today, I will waive the interest. So again, it allows that incentive when you go to collect, that you want to push the client to pay you. Okay, so someone wrote a question in, Lisa. Should you include an interest provision with the government, such as the state of Illinois contracts? Well, you have to look at, because the state of Illinois, everyone knows, if you've been around the last 10 years, they don't pay their bills, or they pay them very slowly. So whether or not you're allowed to do that, this is why it's chat disabled. I don't think it is. I can see it. But whether or not you're allowed to do that depends on the state of Illinois and whether or not they pay you. Because the state of Illinois is its own, like they're their own king of the kingdom. So they will say whether they will pay them or not. So that one's trickier. I don't know the answer whether you can, because a lot of the billing is set by the state. A lot of the provisions, how you bill, when you submit invoices, things like that. So I don't know the answer whether you can, and you might have bid on whatever it is the service you're doing, and there might be specific provisions saying you can't charge interest. So I don't know the answer to that one. So you might want to look at the specific agency that you're doing work for, whether it's Health and Human Services or Consumer Protection or whatever it is you're doing for the state, whether it's prohibited. Or if you were awarded a contract and you're billing under the contract, I'm assuming the contract would say they don't have to pay interest and you can't charge it. But so I don't know the answer to that one specifically, right? So the first question, I don't know the answer to anyway. Sorry about that. Okay. All right. Anyway, so I will move on that one. Okay. Let me put this over here. Okay. Moving on from interest, let's talk about attorney fee provision. Actually, let's go back to interest. One of the things you can also put in when we talk about provisions, because don't forget, you're drafting this contract, whether it's a proposal or a written contract, you're drafting it. So you should take time and develop something that's clear, not super intimidating, but that people will sign. And in that contract, again, we put interest in there. I always put something along the lines of bounce checks, because again, if someone bounces a check to you, your bank might charge you $50 or $100 or whatever that is for processing it, because banks just routinely charge way too much for those things. So So you should definitely put one of those in as well, if I haven't gotten to that in a future slide. But let's talk about attorney fee provision. So in America, how it works is that if you sue somebody, you are not getting your attorney fees unless two different things happen. So the first thing, there are certain statutes which allow recovery for attorney fees. So those statutes are things like discrimination, like disability discrimination, sex discrimination, those kind of cases, because the courts want to incentivize, and the government wanted to incentivize attorneys to take those types of cases. So, to protect like a disabled person or a person who's discriminated against. So those specific statutes that talk about, Title IX, all those things about discrimination, those all have attorney fee provisions in them. There are certain consumer protection statutes you can sue under. Those have attorney fee provisions in them. But for the most part, breach of contract actions, we'll get into unjust enrichment actions, things like that, they have no attorney fee provision in them. So for that reason, if you have no attorney fee provision in your contract that you drafted, you will not get your attorney fees. So let's talk about an attorney fee provision. As long as you're putting together a contract, if you put in 2 or 3 sentences saying something along the line of, if there is a dispute with this contract and we have to file suit, the prevailing party will recover their attorney's fees and costs. Or you can say that, if you're called ABC Plumbing, I probably shouldn't use ABC Plumbing because that's a real company. But if you're ABC Ironworks and you write your contract, you can put in there, if we have to file suit, ABC Ironworks will recover its attorney's fees and costs, kind of thing. And the reason you put that in there is because it's a great, we felt like a sword to threaten your customers with. So when a client comes to me, that's the first thing I say is like, do you have an attorney fee provision? Because if you have a $20,000 contract you want to file suit on, the first thing I do typically is I send a demand letter. I say, ABC Ironworks, was hired to create this fence. We created it, we installed it. You owe us $20,000 and you won't pay. If you do not pay me within 7 days, we will sue you for the $20,000 plus interest at 18% because we added in that language, plus our attorney's fees and costs. Okay. So if you're able to say that, all of a sudden your customer's eyes light up like, oh, if I don't pay this, I have to pay their attorney's fees as well. Because, $20,000 bill, when you add in attorney's fees, if they go to trial, it could be another $10,000, $15,000, right? So it's an incentive for a person to do that, for your customer to pay because they don't want to be stuck at your attorney's fees. And again, if it's not written in your contract, if you're not suing under those specific like discrimination statutes or certain statutes, which there's very few that have it, you will not get your attorney's fees. So when clients come to me, they say, oh, I have, I want to file suit and, it's a $6,000, say the balance is $6,000. I say, I said, it might cost you $6,000 to get $6,000, right? Because just to file a lawsuit, if you file a lawsuit, just the court fees alone are typically just under $1,000, right? It's a filing fee. You have to go through the sheriff to get service. That's $100. The filing fee is usually about $300. It really starts adding up. So having that attorney fee provision is very helpful. And I would say no one really reads these contracts. Your customers don't read them that hard. And if they do, if you put that prevailing party, they typically don't object to it. I have a lot of clients who come to me, especially a lot of, contractors, people who work on people's homes and things like that. So you're dealing with customers, individual people, and they say, oh, well, I don't want to scare off my customers. And I say, this one line about interest if they don't pay, they shouldn't be scared of that because they should assume they have to pay, right? And the 1 or 2 sentences about an attorney, first off, it's usually down here. People are looking at the prices or looking at, the terms. A, they typically don't read it, but B, if they do, if you word it in a way that's simple and it's fair, that protects them as well too. And they shouldn't go in anticipating that they're going to breach the contract and not pay you. And if they do, that's a sign maybe you don't want to do business with them. But again, so I would suggest putting it in. And if someone gives, if a customer gives a big stink about it, then you should, you can always strike it out if you really want that customer, but you should think about, why are they putting a big stink about this too? So I don't know. And then talk to your attorney about it if you have one. Okay. All right. So make sure we have no other questions right now. Okay, good. All right. Okay, so let's talk about executing contracts. Again, who should sign your contract and how should you sign it? Okay, so typically with a contract, you want your actual customer to sign it. And when I say that, sometimes, especially you go to someone's house to, I'm going to fix their roof. You want to make sure you have the homeowner sign it, not a tenant, not the tenant's brother, not the, someone who has no interest in what you're doing. You want the actual person who can bind the company, or who can bind the homeowner. You want them signing it. And we want to talk about how you sign a contract. So I'll explain that in a second. You want to make sure you're not guaranteeing a liability for your company, for your employer, or for another person. So let's get into that, okay? Okay, so if you're an officer of a company, so you have a corporation set up or an LLC, you should never sign a contract knowingly in your own capacity. So if you look at how I have this written out, so Julia Smolka, that's me. I should never sign a contract, Julia Smolka, that has to do with this company. A new Xerox machine is coming in. I shouldn't just put Julia Smolka. Because again, I don't want the Xerox machine people to sue me if Robbins DiMonte defaults, right? You want them to sue Robbins DiMonte. So if you look at how I wrote it next, I put Julia Smolka, comma, not individually, comma, but as a member of Robbins DiMonte Ltd, right? So again, I'm not suing. So in the first stance, the first way I wrote it, I'm signing in my personal capacity. So they can sue Julie. Like say I quit this job and I, work somewhere else. They can find me and sue me, even though Robbins DiMonte defaulted on the Xerox lease, right? But in the second instance, they can't, because it's very clear to the Xerox company that I'm only signing, not in my own capacity, not as Julie, but as a member of Robbins DiMonte. Again, I'm binding Robbins DiMonte, not myself. So keep that in mind. And we can spend a whole hour on that kind of stuff. But anyway, how you sign your contract is important. So, because again, you don't want to personally be obligated on a contract that's a business contract and that you have a business for, right? All right. So let's talk about a guarantee. So again, we're going to take 1 minute to talk about this. So a guarantee is typically placed after you sign a contract, or after you sign a vendor credit application. So let's talk about the scenario. So the scenario is you own a supermarket and you want to get meat from a meat distributor, because again, the store needs meat to put in the, the display cases. So you have to apply to, J&J Meats, and you say, okay, we want to enter into a business contract. We want to order, 100 steaks a week, 100 pounds of whatever, blah, blah, blah. So you do an actual business application. And again, Julie signs the application the application is in the name of the grocery store. And then you fill it out and you want the customer to be the grocery store. typically later on in the agreement, there might be a guarantee that they make you sign. So just be wary about it. Talk to your attorney or your accountant about it. Because again, if your store defaults, you want to have as few guarantees out there as possible, because you want to be able to close the store and not have the debt of the store follow you throughout your life. So what a guarantee says, if the store closes, I, Julie, guarantee the debt of the store. So we don't want to do that if we don't have to. And if we have to do it, we want it to be a knowing choice. Like, do I want to stick my neck out there for this store and have to worry about this debt 10 years from now, right? So that's just something to keep in mind. But it might be where you really need the meat, and that's the only place to get the meat, and you might make a knowing decision, okay, I'm going to guarantee this. You see the guarantees a lot with buying large equipment, with leases or with rental leases, like you're renting a storefront, you're renting real estate. Or you're borrowing money from a bank, like a bank. You typically have to guarantee for the bank to work with you, right? So just go into it knowingly. Try not to guarantee things, but sometimes, again, you want that lease, you want that home, or that piece of equipment, you're going to do it. But just know what you're doing. Okay,
Julia, a few questions just came in.
Oh, okay.
Is a guarantee necessary as a professional service provider?
It depends on who you're dealing with. Again, it's necessary if you're a professional service advisor, like, so for instance, a law firm, I do professional services. It's necessary if the person you want to deal with is insisting on it. Okay. So if I want to set up my own law firm and I go to a storefront to put, to open my business, and I want that storefront, if the landlord says, I'm not giving you the storefront unless you guarantee it, and I really want that storefront, and that's where I want to go, then yeah, it's necessary. You try to not do it at all. But again, it depends on what you're trying to do. Now, if you set yourself up as a company, as an LLC, as a whatever, a corporation, and you conduct yourself that way. So again, a lot of my clients, they think they hired Julia, but really they hired, if you look at your contract with me, you hired Robbins DiMonte, okay? So I don't have a one-on-one contract with them. And so even though I'm doing professional services and you call me, you don't call the switchboard, and you, again, think Julie's your attorney. In reality, it's Robbins DiMonte. But everything I've ever done has been in the name of Robbins DiMonte, right? So if they turned around and sued, like if they say I screwed up a case or whatever, they couldn't sue me, Julie. They could only sue Robbins DiMonte. That's why you set up that corporation. That's why you do that. So when we talk about professional services, if you always operate under your corporation and you do your stuff on your corporation, you shouldn't be sued personally. Doesn't mean you're not going to be, but you have a defense to it. You say, no, you weren't doing it. But when you sign that guarantee, or people have no idea you're in a company because you never mentioned it, it's not on any of your letterhead, it's not anywhere, and they say, oh no, I was always dealing with Julie, then it's a question. But if you sign a personal guarantee, if you take it to that next step, you're personally liable. So again, you don't have to, but if you want that money from the bank, if you want that lease, and that's a condition of it, then you sign it, and then you're stuck with it. So a lot of people, when they remember COVID hit, you got that COVID relief money, all those initial things, most of them didn't have personal guarantees. They weren't huge amounts, but they didn't have personal guarantees either. But when people went through the SBA for these large, I think they're called EDIL loans, and there were 100,000, 200,000 for these businesses, those are all personally guaranteed. And you did that. You had to do it in order to get the money. And same thing with going to, again, you go down the street to Bank of America and ask for money. They're going to make you personally guarantee it, right? And the other thing that you, as a business owner, if you have a credit card in the name of the business, it says the business name on it, there's always a person who guaranteed it. And again, typically you go online, you get a business credit card or you call, you guaranteed it because they wouldn't send it without a personal guarantee. But anyway, so to answer your question, you don't have to do it, but then you might not get the item you're looking for, the money you're looking for.
Great. Another question.
Sure.
How does a guarantee get stated in the contract?
Well, it's typically not. So you look at your contract that you're signing. You look at who the makers, like who's the contract between. So, okay. So say it's a bank. Your Bank of America is borrowing to, again, I'll use Robbins DiMonte, the firm, blah, blah, blah. And if their names are the only names in there, then Julie Smolka isn't liable. But if Bank of America is borrowing to Robbins DiMonte and Julia Smolka, then I'm just in the contract and I'm a party to the contract. So they could sue Robbins DiMonte if there's a default, they can sue me. But typically a guarantee, it is a separate document or it's the second, it's like attached to it. So you see this a lot in real estate leases. The lease is, so-and-so property, and Robbins DiMonte to rent the office space. But then the guarantee is attached to it and it says, Julia Smolka guarantees the lease of, 216 West Higgins to, the landlord for Robbins DiMonte. If Robbins DiMonte doesn't pay, I agree to pay it. The language is written that way. So typically, if you go to a bank, it's a separate document that comes in the big pile of documents that you go through. So if you're getting a larger loan, you should make sure you sit down with a lawyer and say, this is what they want me to sign. And the lawyer will, yeah, you're guaranteeing it or not. You can ask the banker, but people typically don't ask the banker, or the banker might tell you, yeah, you're doing it. So it's typically a separate document, but that's in the bundle of what you're signing. So again, on the lease, it's a 15-page lease. The guarantee is the 16th page, okay? Or you'll see it on the vendor applications, and I've seen this a lot, like Caterpillar, Caterpillar, the diggy companies, they have like a vendor application and you sign it for the company, then right under it says, guarantee. And it says the person who signs this is guaranteeing the debt to blah, blah, blah. And you sign down there. So that's it too. So it's kind of obvious, but if you're not sure, get an attorney. Because again, say, this is a good example. I had a client who she opened a gym. Okay, and they had this lease for this space and they borrowed money to put it was Trex equipment and, while gyms don't seem like it, there's a lot of equipment in there. Typically it's $100,000 for even a smaller gym. That's how much equipment is in there to give it a go. And, she had a partner. And the partner, so her and a partner both signed the lease, they both had, and then within a year, the partner's like, I'm out, this isn't for me. And the partner skedaddled. Well, coronavirus, what happened to most of the gyms, look around, like 2/3 of the gyms closed, right? So that my client, who was the one stayed there, she wound up having to close. We filed the bankruptcy for her. Well, lo and behold, the partner from 5 years ago, she was still on that lease. And she's calling me up frantic. Well, what do we do? Hey, you're on the lease. I don't have to tell you. Go get your own attorney, is what I told her. I said, you're going to talk to an attorney. But again, because she signed that and it was, attached to that lease. And that didn't go away because she walked away from the business. And she was trying to say, well, I haven't been at the business for 5 years. Well, she didn't, even if she let the landlord know, the landlord didn't have to let her out. And the landlord didn't let her out. And so what happened to this woman, I don't know, but again, the landlord went after her. The landlord contacted her because that's who was left on that guarantee. Any more questions on that? Or
At signing, what if you own the company and it's named after you?
Well, so generally, okay, so here's an example, I think is what you're saying. So the company is called Julia Smolka Enterprises, Inc. And I signed Julia Smolka. Again, you should always put not individually, but as a member of, or as owner of Julia Smolka, Inc. because again, you want to have that Inc., have that LLC. You want it prominent that they're dealing with Julia Smolka Inc., not Julia Smolka. So if the contract just says, Bank of America and Julie Smolka, I would change the contract. Be like, no, you're giving money to Julia Smolka Inc. And as long as you're incorporated in the state of Illinois or whatever state you're in, and you sign that way, it shouldn't go after you personally. And if you're not sure, that's right. Like most people don't put their full name Inc., right? Most people put like Julie's landscaping, right? Or Julia's whatever. So it's kind of obvious it's not it. There's very few companies you see like it's the person's name Inc. But again, if it is, it might be Julia Smolka Enterprises LLC or something. Again, you just have to make it very plain to whoever you're dealing with that you're a company, that they're not dealing with Julie, they're dealing with Robbins DiMonte, right? Or Julia Enterprises Inc. So your website, Julia Smolka Inc. Your email, Smolka Inc., right? Inc. You want it all over, so they can't go to a judge and say, Julie confused me. I thought I was dealing with her. I didn't know there was a company. Again, if your business card and your email and your website and you're incorporated and what you have has ink all over it, INC, not INK, but INC, then the judge would be like, what are you, dumb? like you were dealing with a company, you should have known, right? And any more questions before we move on?
Nope, that's all.
Okay, great. Okay. All right. So typically, again, if you're signing twice, if you're signing on 2 lines, you're probably signing a guarantee. So stop what you're doing if you're not sure. And again, we talked about this. If you have a credit card and a company name, you're personally liable. The other thing that's really hot right now is people are getting these, they're called like, they're like these private loans, cash advance loans, merchant capital loans, they're called. All of those you personally guarantee. But they send it to you in DocuSign, you're just like, and all of a sudden, like, whoa, you just personally guaranteed something. Because they send it in DocuSign, and half the time you're on your phone, you don't even see what you're reading, what you're signing. But assume if people are giving your company money, you are guaranteeing it. Assume it. And then just think, if I take this money, what happens if we fail? And then, if you have to take it, you take it, but just know what you're doing. Okay. So if you're doing work, providing a service, make sure you want that contract protection. Again, if you're doing work for husband and wife in a joint household, have them both sign, right? Especially if you don't know who's the technical owner of the house. Sometimes just the wife owns the house, but the husband's there signing. And again, if you're making repairs to a property, have the owner sign if you can, not an agent. But again, if there's a property manager, then the property manager can bind the owner. Okay. But again, we just want to make sure, if at all possible, have the right person sign the contract, right? And don't start work without a contract being signed. And again, it's very tempting if there's, oh my God, there's a flood in the basement, we have to start right away. No, take 20 minutes and get a contract. So hopefully all of you have a contract, either some kind of a QuickBook where they have a contract in there, or you have like a pre-printed contract that you can fill in the terms, but you have all that other language, the attorney fee language, the interest, where to pay, things like that, your payment terms. If you're in a job that is such where you go out and you make emergency repairs or things are done quickly, have that pre-printed contract that, again, you can have it carbonized where the person signs it, or you can have them, email to someone's phone and then they can sign it. But don't be tempted to start work without signing a contract. And again, even I'm like, people call me I have court tomorrow and I'm getting sued and oh my God, blah, blah, blah. And again, their emergency isn't, I got to still stop what I'm doing. I'm like, okay, well, I can represent you. Here's my contract. You need to sign it. And I need a deposit before I even go. Okay. Don't be, again, their rush, their emergency is not your problem. You need to protect your company and you need, and again, because if you do these things and you do stupid things like starting work without a contract, again, you're harming yourself and you're harming your employees if you can't pay them because you have money problems, or your spouse when, you know, again, when the money isn't coming in, because you're better off not taking a job, right? You're better off not taking a job and having that risk than, you know, doing all the work and not getting paid. So one of the things I tell my, the younger attorneys here, is that like, hey, I can stop, I can do all this work. And if I'm not getting paid, like, why am I working for a customer who's not paying me? I'm incurring risk of being sued. I'm incurring, if I'm driving to court, what if I get hurt in a car accident? What if I, you know, if I have to pay for stamps or I have to pay for, why am I doing all this and taking this risk if the person is not paying me, right? I could be, you know, sitting home on my couch and watching TV and making the same amount of money, which is none, right? And having no risk. So same thing for you. Don't be like, oh my God, you got to send it right, you got to do the work right away. It's like, no, we can take an hour. We can get it done right, get the documents signed, get your deposit, and then you can start work, right? That I always say. Okay. All right, so we talked about these personal guarantees. They destroy what we call asset protection. So again, you do these guarantees, you setting up the corporation. Actually, here, I'll back up. Most of you, if not all of you, if you're doing business, you should have a corporation. And it could be a corp, an LLC, a limited partnership, call it LLP. But the reason you set those up, again, is so that if something bad happens, you know, a customer slips and falls at your shop, you know, you build a roof and it collapses on someone. If something bad happens with your business and with work that your business does, you don't want it to affect you and your spouse. You don't want it to, you know, you get a money judgment, you know, it's $100,000 money judgment. You don't want them coming after your personal assets to satisfy the judgment, right? So that's why you set up the corporation, LLC. You know, doctors have LLCs, lawyers, accountants, even. Any kind of construction person should have one, because again, there is a chance something goes bad and you're sued. You want to protect your personal assets. All right. But when you do that personal guarantee that we talked about, that gets around, like, here's your corporation protection. The personal guarantee gets around it, and here's all your personal stuff. Okay, so just something to keep in mind. So if you're sole proprietorship, if you're just Julie Smolka, lawyer, and I have no company behind me and I just start practicing law, if I'm sued, if I, you know, miss a deadline, or I, you know, a client thinks I screwed something up, and a judge agrees and there's a money judgment against Julie personally, again, they look to my car. My car is, you know, named, you know, I own my car outright, you know, it's probably worth $15,000. They can come and take my car to satisfy that judgment. They can take money I have in the bank. Again, Julie's money. Julie and, you know, my husband's name is Matt. Our money, they can come take it if I'm a sole proprietorship, if I don't have that corporation. So that's why you don't want that. And to set up a corporation, it's a few $100s. It's not crazy expensive. And you can work with a lawyer and accountant to get that done. All right. And there's certain things you have to do. We won't get into that so much. A corporation, you know, is the first layer of protection. The best, you know, with the corporation, so you have a corporation set up. So Julie Smolka Inc. If there's a judgment against Julie Smolka Inc., there's a way to, they could try to, what we call pierce the corporate veil, to get at the assets of Julie, all right? And it's a drawn out process, but if I don't do certain, and we're not gonna spend a lot of time on it because we can. If I don't do certain things, they could try to come after my personal assets, okay? If you have an LLC, this is what I recommend. Again, for asset protection purposes, an accountant might recommend the corporation for other reasons, for tax reasons, but an LLC, they can't pierce that veil. So again, it's full protection, and a creditor can't try to pierce that veil or go after the individual if it's an LLC, right? So that's something to keep in mind. And again,
Another question came
Sure.
in, if you're ready.
yeah, go ahead.
Some large companies only pay for 30, 60, or 90 days. How can you get those companies to deviate and lower the amount of time to 15 days? Some are not willing to change for small contractors.
The only thing you can do is ask, right? And if you're dealing with a large company, they have the ability of being a large company, so they don't have to do that. Does that make sense? Like, they set the terms. If you wanted to go, and try to get, business from Amazon. Amazon's the biggest company in the world. They set the terms. You don't. Same thing with the state of Illinois or the city of Chicago or, big hospitals or big, again, all you can do is ask, but if you accept their payment terms, you have to deal with it. It's just the cost of doing business with that individual company. Because again, there's nothing in the law, there's nothing forcing the issue. It's what you agreed with, right? So you can ask, you could, there's certain things you can do to make it quicker as well. Again, certain companies, you can send electronic invoices with a link, to your bank account where they can just pay it. That sometimes gets you paid quicker rather than waiting for checks and waiting for the mail and things like that. But otherwise, again, big companies, they set how they do business. You want to do business with McDonald's, McDonald's sets how you do it. So there's not much wiggle room. The wiggle room comes into when you're dealing with someone and they want you as much as you want them. And then maybe you're saying, okay, we'll do 15 days or we'll do COD or we'll do this. But yeah, there's really nothing you can do if that's how they do things.
Okay, great. That's all the questions right now.
Okay. All right. And again, so if you have the company set up, make sure you use your LLC in your name. Make sure it's on your website, on your signature, on your business card, on your invoicing, so that they know they're dealing with not Julie, but Robbins, DiMonte, right? And again, you should sign all your contracts with the president or whatever. Okay. Again, if you're a sole practitioner, just stop it. Just become a corporation or an LLC, ideally an LLC. If you're already an LLC, congratulations, right? Okay, so let's talk about collections of receivables. So by this point, you had a contract, you did the work, the customer only paid you half, and then they said, I'm not paying you, screw you, whatever. What can you do? So you have to file suit. Like, you can't just go out and grab their assets. You can't go out and grab their things. Like, if you have a deposit for them, like if for some reason your contract talks about deposits, depending on what your contract says, you can apply those deposits, but you have to sue the people, right? So even if you just sent it to like a collection agency, all they can do is harass people. They can't do anything else. So again, sometimes harassment's enough. I mean, think of if you had an old medical bill, they call you every week, right? So sometimes that's enough. But collection companies can only call. If you want something more, you have to go to an attorney. And if you're a company, you can't sue in yourself. You can't just go to small claims yourself. You have to have an attorney. It's like the law in Illinois. So you hire an attorney, you file suit, you get a judgment. So again, you have a trial, the judge decides who's right, and you get a money judgment. So once you get a money judgment, if it's against an individual, you can garnish their wages. So in Illinois, you're allowed to take 15% of your gross wages if the person makes more than poverty level, okay? So it's 15% before taxes are taken out. So if the person makes $100,000, was that 15,000 a year you're able to get? Now, on your judgments, there's interest, okay? So if it's a consumer debt, meaning your contract was with a consumer for a consumer product, it's 5%. If you're a business and you dealt with another business and you have a debt and you have a judgment against a business or an individual in business, like for instance, if a bank sues like the president of a company who defaulted and they have a judgment on a business loan, that interest rate is 9%. Okay. So that's something to keep in mind. So these judgments are accruing interest. So you can garnish someone's wages if you know where they work. You can garnish bank accounts. Okay. So if you know, like your customer always paid you from a Chase bank account and you get a judgment against them, as an attorney, I can send a thing called a citation. I can send it to Chase and say, tell me all the money that, John Smith has at Chase. I want it. And again, so what they'll do is Chase will freeze all the assets of the person who owes you money. And then you go to court and you ask that it be turned over. And if someone has an account, like for instance, if you had a judgment against me and I had an account with my husband, even though his name is on it, you could still get all the money in our joint account. Okay. So that's a super powerful tool. So how it's relevant to you is when you're getting along with this person. So when you're nice to this person, before you suit them, before they stick you and you suit them, you should find out, like, oh, where do you bank? Where's the, where do you work? Again, in the small talk, if you're, at a home, oh, where do you work? Blah, blah, blah. And they say, oh, I work at Robbins, DiMonte, blah, blah, blah. Write it down. Or, oh, I bank at Chase. Or when a customer pays you, make a Xerox copy of the check, right? You keep it in the file. Because again, it's much easier to find this stuff out before you're fighting with the person. Okay, find out where they work, find out where they, where they live, find out where they bank. What other, if you're working with another business, oh, who else do you work for? Who are your big customers? And again, because one of the things that we can do is, if you have a lawsuit and you get a judgment against the company and they do, like, oh, they're always doing work for Walsh Construction, they're a sub of Walsh's, we can serve a citation on Walsh saying, hey, any money you're going to pay to the person we have a judgment against, pay to us instead. So that's a tool we can use as well. But again, as far as collecting, some of the things we can collect are cars, stock in a business, tax refunds, inheritances. We can place liens on real estate. So if you got a judgment against me and I had a house in my name in Cook County, you record the judgment with Cook County and it's a lien. So when I go to sell, it had like a closing, a title company won't let me sell until that lien is paid off. Okay. And there's a way to collect on individual trusts and land trusts. We won't talk about that today because that's another hour. So again, at the beginning of the relationship, find out where the person lives, find out where they bank, ask about customers, jobs, current relationships, like get to know their business or get to know them a little bit. And again, it'll seem genuine, like you're interested in them. And then when you get back in the car, write it down. Like, oh, I know they work at Chase, they bank at Bank of America, they do this, they have a summer home in Wisconsin, whatever it is, just make those notes and just shove them in the file because you never know when you might need them. And that's stuff that I, as a collection attorney, would use to try to collect and pay off the judgment that we get. Okay.
A few questions coming in.
Sure.
How much time, years, do you have to file for collection judgment after the due date?
Okay, so what he's talking about, or she's talking about, is statute of limitations. So on a written contract in Illinois, the general statute of limitation is 10 years. On a credit card, if it's a credit card, that's considered an oral contract. That's 5 years. And if you have an oral contract with someone, like, hey, Julie, do this legal work, blah, blah, blah. If it's just an oral contract, that's 5 years from the default, okay? So if we were going fine, every month I did work for you and every month you paid, and again, say we were doing work for 10 years, 9 years, but we only had an oral contract, again, it's 5 years from the default. So you default and I have 5 years to file suit. But typically, like I said, written contracts 10 years, a written guarantee is 10 years. So for a lot of people, like the company goes under, they kind of forget about it, and all of a sudden, like year 8, that vendor debt you get sued on, right? And I forgot all about this. Yeah, well, they had 10 years on that written guarantee. So typically it's 5 years and 10 years. Okay. Are there any other questions?
Yes. What if a company has agreed to pay you on a certain date verbally and then don't pay?
Well, then they breached, right? So hopefully in your contract, you state, payments are due every 30 days or upon completion, and you complete. And they say, and the person's like, oh yeah, I'll pay you on the 25th. That's when I get paid. And again, they don't pay. Then there's a breach and you could file suit, right? But again, typically first you try other methods because just suing is expensive.
Okay, another question. Is it legal for the original creditor to sell the debt to another office and restart the dates of the statutes?
Well, it's legal for them to sell the debt. It's pretty common, especially, I don't know if you remember, like mortgages sell the debts or it's super common. The dates don't change though, okay? So you have a credit card, like credit cards are notorious for selling to collection agencies or those kind of places. So you have a credit card debt. If your last time you paid was 6 years ago and they sold it to somebody else, last week, they don't get another 5 years. It's 6 years from your default. So yeah, so again, they can sell it all they want, but it's your action that sets the timing, not anything they do. Does that make sense? Your breach. So
yes. A question on any recommendations on contract or contract services to use. Rocket Lawyer was brought up.
What was brought up?
Rocket Lawyer.
Yeah, that's all garbage. Because again, those are national forms. I guess it's better than nothing. But I know like QuickBooks has some forms, and again, Rocket Lawyer might have some. The key is to try to get a form that makes sense for whatever it is you do. Again, because you don't want to be like a contractor who's doing a form for like selling something or, so you kind of want specific. So what I've done for clients is, and it's relatively inexpensive, I have them like, I don't say create a form, but saying, this is what I think I need. They either pull it, they either had something in QuickBooks or they had something they had from before, or they work with someone else and like their contract, you can't take it. And then I ask them about their business and I like, okay, well, in reality, the way you bill and the way you do work, we want it. So for instance, more heavy, if they have to put out a lot of money to do the contract, does that make sense? So we have the deposits. And so I create the terms so it's best for their business. And then I add in some terms, and it's usually that might be an hour or two of time at the most. And we create a form contract that they can use over and over. But as far as individual, like online stuff, I don't know of any of those. I mean, I'm not familiar with any of them because I just draft my own contracts. But again, something's better than nothing. But a lot of times people like piecemeal junk together that they find online, and it's either not applicable for what they do, or it's not valid for what they do, or they have like weird provisions that, like, oh, this contract can be enforced in Nevada. It's like, well, why would you do that if you're an Illinois company and your customer's in Illinois? So again, if you're going to be using these a lot, I suggest, getting what you think is a good form and working with an attorney to like tweak it so it makes sense for what you do. And it's not terribly expensive to do that. Because again, this is your livelihood. You do want quality, good forms you know, and then if it's bigger things, like bigger construction things, again, it's more incentive to spend a little bit to make sure that they're right. Anything else?
Just does that still end up on your credit?
It does what?
So
Okay.
it's a double question. Is it illegal for the original creditor to sell the debt?
Oh.
And then the follow-up question was, does this still end up on your credit?
Okay, does it end up on your credit? So I don't know if people realize this, but most business debt does not end up on your credit. Okay. So one of the things I do is a lot of bankruptcy work for people and companies. And like, if you're borrowing money from Caterpillar for a machine, or a lot of business debts don't end up on your credit because those people don't report to credit agencies. Any kind of credit cards, like they're in the business and they're set up to report it on your credit. Any kind of, like home loans, they'll show up on your credit. Because again, that's what they do. You know, if you go to Old Second Bank and get a business loan, they're not consumer creditors, so they typically don't report to credit agencies. So again, keep that in mind. Business debt is typically treated a lot different than consumer debt. But things like the credit cards, those typically end up on your credit, even though they're business credit cards or vice versa. If you have old debt that's sold and I think something can stay on your credit for 10 years, maybe, or 7. So look at what it is. And when you go to the Experian or the TransUnion, you could object to those specific things, saying why they shouldn't be on there. But even though something is beyond the statute of limitations, like if they could only sue you for 5 years for the credit card, it doesn't mean it can't still stay on your credit. Does that make sense? They just can't sue you for it. I hope that answered that question.
Great. No more questions.
Okay, great. Oh gosh, we're going on well over an hour. Again, save copies of canceled checks and just in case we have to collect on it later. Oh, good. All right, so this is my contact information. I hope you found this to be interesting. I know I threw a lot of stuff at you, but again, they did say you could rewatch it again on YouTube. Maybe I'll make my kids watch it today when I get home. But it's great that you guys are entrepreneurs, and it is a great way to make money and support your family. My suggestions are just do certain things to make it easier for you to collect your receivables and to make sure that you're not, in trying to pursue your dreams, you're not putting your future with these guarantees and this other liability at risk. Just be smart about things. And if you don't know, it's worth reaching out to an attorney. And again, an accountant doesn't know the liability parts as much. They know how to set up things, but they're not your resource for, is what I'm doing legal, is what I'm doing the best for myself and my family. So find an attorney like myself. And again, it's, get that consultation when you set up your company, spend a few $1,000s just to, again, make sure your company is set up the best way and that you have the best business practices going forward. You're spending money on signs, you're spending money on your website, spend a little money on this to make sure it's done right. So 3 years from now, 5 years from now, you're not calling me for a bankruptcy because things aren't right. Okay. All right. But it was great talking to you, and thank you.
Great. Thank you so much, Julia. We appreciate your time. Everyone's saying thank you. I enjoy it. Very informative. Great, great, great. So lots of positive feedback coming in. So thank you everyone for attending. Wishing everyone a safe and enjoyable long holiday weekend. Thank you, everyone.
All right. Thank you.